Will Ripple also make a remark on its IPO at the next event in Dubai that is being hosted by Ripple? Why did the SEC order Ripple to hand over more than $700 million in cash? Is it appropriate for Hester Peirce, a commissioner at the Securities and Exchange Commission, to condemn the enforcement action that the SEC took against LB? All this will be covered in today's video. A fresh set of assumptions have been made by John Deaton, who is a Ripple litigation lawyer who is representing thousands of XRP investors. These assumptions concern the part of the case known as the remedial phase. Deaton recently said in a tweet that the Securities and Exchange Commission is so incensed and humiliated that it is demanding $770 million in compensation from Ripple due to its anger and shame. Deaton made this claim. Particularly noteworthy is the fact that Deaton asserted that the figure of $770 million represents the actual value of the XRP that Ripple had sold to institutional investors. You may remember that back in July, the court decided that institutional sales Ripples breached the regulations that govern the sale of federal securities. In compliance with the ruling, the deadline for the parties to submit their proposed briefing schedule is set for November 9, 2023. If the parties are unable to settle on a time that is suitable for both of them, they will ask the court to schedule the remedy stage at the time that is most convenient for it. The party is obligated to submit a briefing schedule since the court ordered it. According to the attorney who provided the briefing, the SEC is requesting the whole $770 million from Ripple as compensation for the sale of unregistered securities to institutional investors. It is noteworthy that he expected Ripple would take tremendous action to considerably reduce the $770 million fine that the SEC is demanding. This is especially true in light of the fact that the remedial stage is soon approaching. Deaton claims that the blockchain firm will make an effort to keep salaries, operational expenses, and on-demand liquidity sales within appropriate bounds. The SEC has requested that Ripple pay $770 million. However, legal experts anticipate that the company will spend millions of dollars in an effort to reduce this amount. The Ripple's lawyer believes that the company will be able to drastically decrease the $77 million figure. Continuing on, during the course of the dispute, LB agreed to lessen the amount that the SEC wanted, as was described by the counsel representing XRP. According to DN, the SEC demanded that LB pay a fine of $23 million because the company sold unregistered securities to individual investors. However, after 8 months of remedy proceedings, the court in the LB case decided that the blockchain corporation should be had to pay a fine of $130,000. Deaton also discussed his thoughts on several other parts of the case, such as the prospect of working with a lawyer who specializes in settlements. He appeared to imply in the tweet that the outcome of the SEC's case against Coinbase would be a crucial factor in determining whether or not the Ripple dispute would be settled. You may recall that the SEC leveled allegations of a violation of securities laws against the San Francisco-based exchange back in June. Since then, the exchange has put in a request to have the SEC's claims dropped, which was entirely predictable. He made a veiled suggestion that if Coinbase is successful in getting the claims against the business drawn, it would compel the SEC to change its position on cryptocurrencies. After this modification, there are conversations on a potential settlement with Ripple that may commence, but he anticipated that there would be no compensation if the cryptocurrency exchange based in San Francisco lost the lawsuit. In the meantime, leading proponents of cryptocurrencies are of the opinion that any SEC litigation brought against Ripples would constitute very serious writing. According to Alina Terrett of Fox Business, although Ripple plans to attempt to reduce the penalties, the SEC is asking a sizable amount of the $77 million in exchange for bribery privileges. In addition to this, she added that persons who are familiar with the matter disclosed that there will be a heated argument when the hearing is taking place. The Chief Legal Officer Stuart Alderody has provided commentary in response to the actions taken by SEC commissioners against a blockchain-based content sharing platform. In a statement that was made public yesterday, Pierre highlighted her uneasiness regarding the enforcement actions that were initiated in March 2022 against LB. Notably, in November 2022, a federal judge ruled that LB had broken the law when it issued unregistered securities under the pretense of LB Credit, a blockchain firm. The judge stated that LB had violated the law when it had done so. Lewis voluntarily withdrew from the action after disputing the decision earlier this year and alleging huge indebtedness as a result of costly legal expenditures in order to pay commitments. In reaction to the announcement, the company also declared that it will put its assets into receivership and begin the process of winding down operations. Pierre believes that the failure of LB is an example of the consequences that can result from the SEC's enforcement measures that are not well thought out. She referred to the case as puzzling and said that neither the SEC nor the court uncovered any proof of misconduct by LB, although there were other efforts that were obviously fraudulent and did not seek to comply with the securities regulations. She said this was confusing because neither the SEC nor the court identified any proof of misconduct by LB. She questioned why pursue a business that sold a token for a blockchain that was functioning, but had not yet been put into use. In reaction to this, Pierce asked for feedback on how the SEC should improve its crypto innovation course in order to prevent a situation like this from occurring again in the future. Alderody was grateful to the commissioner for openly opposing the enforcement measures that the SEC was taking against. In response to a question, the chief legal officer at Ripple stated that Pierce ought to cultivate the habit of speaking up more frequently and earlier when justice is achieved in circumstances that do not include fraud, such as the LBI lawsuit. Pierre explained that she abstained from publicly expressing her concerns regarding the LB issue while the case was still pending, which is what prompted Alder to make the offer. Pierre indicated that she refrained from publicly expressing her concerns regarding the LBI issue. Pierre was encouraged by Alderody to submit an amicus brief in support of several cases that did not involve fraud. Unexpectedly, attorney John Diaton agreed with Alderody's assessment, highlighting the necessity for Pierce to go above and beyond and file an amicus brief in these instances, given that 75,000 individual holders intervened in court to express their concerns. Diem's statement came as a response to Alder's assertion that there is a need for Pierce to go above and beyond and file an amicus brief in these cases. In addition, a significant Ripple event referred to as also will take place in about 3 weeks. As a result of this, there has been a lot of talk about the potential that Ripple may make some significant announcements on going public during the conference. There was widespread speculation among influential participants in the XRP community that Ripple might take advantage of this chance to formally announce its intention to do an initial public offering, IPO. Deaton, in my opinion, the moment has come for someone who is familiar with the situation to testify in court. An engaged member of the community known as Rukau Kanan is driving the conversation surrounding the revelation that Ripple will be holding his IPO at as well. He admitted that the meeting had important repercussions, but he also offered some forecasts as to what will occur with the XRP. And Numeric provided an explicit overview of the primary potential outcomes of the conference in Dubai, with an initial public offering, IPO, placed at the top of the list. This is especially significant in light of the continued triumphs in legal battles. In recent weeks, there has been a surge in the amount of attention paid to the topic of taking the company public by means of an initial public offering, IPO. In addition, Ripple has just posted a job opening for a senior shareholder, which may be a hint at the company's preparations for an initial public offering, IPO. The communications manager for the XRP community is certain that Ripple will go public at some point in the future, and as a result, they are eager for Ripple to announce the IPO during significant events such as Swell. WFC and other members of the community are anticipating that Ripple will talk at the conference about the process of obtaining a license from Virtual Assets Regulation Authority. In addition to this, they anticipate learning more information regarding Ripple's central bank digital currency effort, developments in tokenization and stablecoins, as well as the introduction of new customers to Ripple services. Swell will be a conference that takes place over the course of 2 days in Dubai on November 8 and 9, 2023, as stated on the Ripple website. That's all for now. Thank you for watching.